Hey everyone, Harry here to set up the big closing arguments tomorrow. So in New York, the defense will go first, about 3 hours, and then the prosecution second, about the same. It may fill up the day so that the instructions that the judge gives the jury, it's possible they'll come Wednesday morning, or they may be at the end of a very long day. Now, I've been talking a lot through the trial of the apparent absence of any kind of real narrative, any reason for the reasonable doubt for the defense to offer the jury. And we did a different tape today. You might want to check out where I really dive into the suggestion from the New York Times, which obviously has been talking to them, that they're going to have the missing man closing argument, the missing man being Alan Weisselberg. But let's just figure out what the basics are here and where they're going to be going. So recall, we have 34 felony counts. Each of them is anchored or bottomed by a misdemeanor count of falsification of a document, either an invoice or a voucher or a check. 12 of one, 11 of the other two makes 34. And they are all false, pretty much expressly, but maybe implicitly, which is fine, because they represent falsely that the Trump organization is paying Michael Cohen for legal services when in fact it's reimbursing Michael Cohen for a hush money payout to Stormy Daniels. So that basically sets up first, that's got to be false. And it looks as if the defense, at least in their opening statement, they were going to go at, this seems an overreach to me. And in fact, Todd Blanche said in his opening statement, these weren't false. They were actually for legal services. This is the time at closing argument where the prosecution can make him eat that word by word, and say, you know, he promised you, Mr. Blanche, in the opening. Well, did he do that? No, it's obvious these weren't for legal services. You know, if the jury believes that they weren't, that really, you know, totally undercuts Blanche, not just their witnesses. Of course, they had no witnesses to speak of except Bob Costello. Okay, but so there may be, you know, they may actually try to argue there's a reasonable doubt as to the falsity, but it doesn't seem to me to get anywhere. But what's going to be the focus, both evidentiarily, I think that's a word I just made up, in evidence and in law, is the intent that Trump had when he just has to cause them to be false. So it doesn't matter that Weisselberg generates, as long as the jury accepts the, you know, continual refrain from all witnesses, friendly and unfriendly to Trump, that he, you know, here's something I think we'll hear in closing, as David Pecker put it. Michael Cohen couldn't go to lunch without Donald Trump's permission. So as long as everyone believes he totally runs the show and is a micromanager, causing a false entry shouldn't be a problem. The intent, however, so there is, as you've been hearing, this somewhat complicated double layer of intent. The misdemeanor is just that he causes it to happen, and he, you know, knowingly. So he doesn't stumble into this by mistake, but he makes a false entry or cause it to happen. I don't think very challenging either, but it does get tricky, because in order to elevate it to a felony, and you know, a whole sort of separate question and theme that it's now time to be thinking about is, if the jury finds a misdemeanor but not a felony, how does that cut? To me, I think Trump proclaims victory, and it's generally accepted that way. So they need the felony, and in order to do that, his intent has to be to further another crime. Crime doesn't have to be committed, doesn't have to be started even, but that has to be the intent in his mind. And there's going to be the intent that they've proffered. There's a sort of general intent of hiding the state what would be a state election law offense, because this is essentially is the $130,000 that Cohen's being paid back a contribution to the campaign. And they didn't want to play it that way and didn't want to have to reveal it, didn't want to have to disclose it on forms, because it would have wreaked havoc and maybe been fatal for the campaign. We have very good, strong evidence from all over the place, Hope Hicks and David Pecker and the like, that the campaign is in meltdown after the Access Hollywood tape has come out. And so now the Stormy Daniels, it's an imperative to cover this up for election reasons. Now, they may try to say, the defense, no, it wasn't. Yeah, he did all these things. Yeah, he knew it was false, but it was to shield poor Melania. But a few things we have direct evidence from Cohen, among others, that he never mentioned Melania. We have Melania's, I think, screaming absence from trial, which the jury would have noticed, not there even one day. And we have the fact, as they'll be instructed, that even if that's part of it, the trying to be helpful or to shield Melania's feelings, if they would have done it for the campaign, that's good enough. So if they're sort of mixed motives, but the campaign motive would have been enough for them to make it, that's gonna suffice. But there's going to be a question of what crime they're trying to further. And we've talked about this in a separate YouTube, but essentially there's a tax theory, a federal law, election law theory, and a state law theory. And the state law theory requires unlawful means. So even as an extra element. I'm trying to give you sort of a medium level of detail. I don't think we have to go too far down the rabbit hole just for the introduction to tomorrow, but to be aware that there's this double layer and this pivotal kind of phrase, unlawful means. What was he wasn't just trying to cover it up, but doing it based on something unlawful. For example, not reporting as required what is essentially a campaign contribution. But so it'll be an interesting strategic call, because that's one that might attract. I think the evidence is pretty strong, and in general, the last point of a defense closing that everyone expects is to, lambast Cohen up one side and down the other, liar, cheater, thief, all those things. To my mind, though, you can be all those things and still be telling the truth, especially since he has a reason for kind of changing his tune at a pivotal point in the evidence. And I think the jury will take him as having basically told the truth, especially since it's a relative judgment. Yeah, Trump and Trump's through his lawyers, since he didn't testify. A fact, by the way, that may not be mentioned by the prosecution. It's a constitutional principle that a corollary of you're not having to testify against yourself. Prosecution can't say, aha, he didn't testify. So they won't mention it at all. But anyway, we have, nothing. They'll still make relative credibility judgments, and they're still on Trump's side. He never had sex with her, and these weren't false at all, and all the things they didn't know. I think the credibility battle, which is going to be the, either A or the key hallmark of the closing, is an uphill battle for them. Okay, so now, so that'll be Todd Blanche probably for the defense, and Joshua Steinglass now for the government. And, he's got a really good story to tell. He has told that story over the course of the trial, but this is the real occasion to really bring it together. So often the presentation of evidence is sort of stilted or artificial. But here at closing, and much of the whole case has been with an eye toward this. He can tell the whole thing. I've said, it's not tying up loose ends. It's the mini series. It's the whole, with a lot of pictures and reading of transcripts and emails and the like. So to just, recapitulate the entire thing, but in a really, narratively well presented and driving and engaging several hours. It's, the biggest moment of his life, the biggest moment of any trial for a prosecutor, but you can bet that he's been, prepared for it he's been preparing for it since before the trial even started. Okay, so that, and they will basically march through. Of course, they were false. Of course, he did it with the intent. You don't have to listen to what they say about Cohen. There's corroboration, etc. So they have a simpler, they have a much higher burden to surmount, but I think it's more clear how they're going to do it, what their story will look like. But something to keep in mind is it'll bring things together, lots of visuals, PowerPoints. Each juror has his or her own screen, and they'll be really following it. And, Steinglass, I think we can really expect to sort of bring home the basics and really show why the story coheres and why, in fact, Cohen, even if he weren't credible, the story would still be there, but that he is. In a nutshell, that's what it's gonna be. Well, obviously, the details are going to really matter. The things he focuses on. Does he, say Blanche promised you this and didn't do it? Are there dramatic flourishes and the like? What's the dynamics of it all? But that's the essential broad strokes of what we can expect tomorrow. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.